All right, Chris, let's talk about the situation with Judge Dennis Galiatsiados. Now, this story goes back over a week, but what doesn't stop is the reaction to the decision. So this is all about him bringing up as a judge the fact that, in his opinion, Bill 96, which contains a provision that a verdict in a case be issued in English, right, simultaneously with the French translation, is simply not workable. He said it's in violation of criminal law principles. So let's explain that really quickly. What does that mean?
Yeah, so just to paint a little picture, we have a courtroom where we have a defendant, an English-speaking defendant, who was accused of a crime that occurred in the West Island, and she opted, as her right, her constitutional right is in this country, to have her trial done in English, and therefore the judgment will be rendered in English. But Bill 96 requires that any judgment that is rendered in English has to be, and the words that they use immediately and without delay have to be translated into French. And what the judge said was, this is in violation of what criminal law suggests. That there's no way that we can accommodate that. It's going to take some time to translate it. And if we go about the system that's in place right now, we're going to have problems. We're going to have some constitutional challenges here. So what the judge opted and asked both lawyers to give their opinion is saying, hey, this requirement is unconstitutional. It goes against what we have in criminal law. And what's funny is it's something that's so small, but the reaction to this, like you mentioned, the politicians that are saying he had no business commenting on this, it's not only his business, it's his obligation as a judge to raise these issues. This is something that the judge can do from his bench. So that being said, it's obvious that this law, if they really were serious about having this translation done, they would have used other terms. Instead of immediately and without delay, they would have used terms that are more functional, that would provide for some delay, that said that the judgments have to get translated as quickly as they can, given the circumstances. But no, they wanted to get political with the way they wrote this law, and they wanted to score points politically, and now we're running into the problems that it causes when you do that. So to answer your question, what is this all about? The actual case itself has no bearing. I'm not sure that the French language or the preservation of the French language actually had it in its sights, this judgment from a West Islander who was accused of a crime, a very serious crime, but accused of a crime in a court. How that being forced to be translated into French has any bearing on the preservation of the French language, it beats me. It's going to get translated eventually. That it has to get done immediately and without delay, I'm not sure that that's what the essence of preserving French language is. And the judge made note of that and said it's unconstitutional. So that's where we are right now. But there's going to be a lot of this coming up. There's no question. And this judge had the wherewithal to raise that issue. I'm not sure if many judges would, but it's absolutely founded in law what he's doing, and it has nothing to do with politics. It's a violation of what our current law system is.
So my question is, from what I gather here, so first of all, the provincial attorney general said, no, you can't, and it was kind of a matter of, they don't have a ruling here. But the objection seems to be, to me, Chris, that it should have been one of the attorneys that brought this up and not the judge itself. Is there any merit to that?
The attorneys can bring it up, but that doesn't. There are many instances in our laws where the judges, by their own decision, can bring something up if the lawyers decide not to. We've seen many cases that have been thrown out because defendants, let's say, for example, a defendant's in English and they want their trial in English, but their lawyer is more comfortable in French and says, you know what, let's just do it in French. It's okay. I'll let you know what's going on. Those cases have been turned over because of that. So judges not only can, but if they see something that they believe would violate the whole trial and be subject to appeal, if someone decides, of course they can bring it up. And it's not only on the lawyers to do so. And in this case, it appears that the lawyers were willing to concede and say it's not a big deal. We'll just work with it. But the law is not like that. The law is set up in a way where you have to protect the rights of someone to be tried in their own language. And not only that, if the laws that we're using within that system present a violation of that, well, then the judge raised it and said, this doesn't work. What you're trying to do here doesn't jive. It doesn't intertwine well with what we have set up in our system. So it just makes common sense. The reaction, though, to me, when I'm reading the reaction from the different political parties, that's where they lose a lot of credibility. When the terms they're using to suggest why he did it and they're putting everything else but the defendant's rights as a priority. That's where I find their argument starts to lose credibility. So it's unfortunate that that's what's going on, but we knew this was going to happen. We knew that this Bill 96 went far beyond what the objective was, and now we're starting to see the effects of it.
This is, at the end of the day, and not to simplify it, but this is really a justice delayed is justice denied argument, isn't it?
It's exactly that. And in cases, we've seen people walk away scot-free because it's taken too long to prosecute. We've seen this. We've had the Supreme Court talk about delays and how they are prejudicial and how we have to do everything we can to limit delays. And now we have a new piece of legislation that's saying you have to have it translated immediately. And that goes against what is possible. The judge mentioned it. It might take weeks. And what's going to happen? Well, we might be subject to an appeal afterwards because of this. So it just doesn't make sense. We're taking something that is, the objective is what? Preservation of French language. To use this area in terms of forcing the translation of a judgment to be done immediately and without delay, it just seems to me more political than functional. And I think that they could have saved themselves a lot of headaches if they would have drafted the legislation in a more functional manner.
Right. I should point out the provincial Liberals pointed out they were against this when it was first introduced. And, of course, they're not the government in power, so it didn't matter because it wasn't adopted. What happens from here, though, Chris, beyond this?
What's going to happen, sometimes, what we've seen is political parties draft legislation knowing full well that it might not pass the test. But the fact that the dialogue and the discussion that comes up and people start aligning themselves with which side they're on, that's enough. So where do we go from here? Well, we're going to see Bill 96 in all the different areas of what they're trying to achieve get challenged here and there. There's going to be judgments that are going to be against it. But at the end of the day, the discussions that we have are going to fuel whatever support they're going to get until the next provincial election. And then, if it's a new party that goes into power, we'll see a couple of steps back and some corrections. But there's no question that the law and the judgments that we're going to get from here on in are going to curb, limit, and shape the way Bill 96 is how far it goes and what the extent's going to be.
All right. Chris, thanks so much. Appreciate it.
Thanks, Aaron.